The Supreme Court recently upheld the ATF's rule, which regulates unfinished frames and receivers. However, now AG Bondi and the DOJ have publicly pulled their support of this rule and pulled their support of one of these lawsuits. This is a huge development, so let's break down what just happened. Now, really quick before we jump into this video, I just want to say that if you guys want to support the channel for free, please consider subscribing. Also, click the notification bell and turn on all notifications. Double check that YouTube hasn't unsubscribed you because they love to do that. And then also just drop a positive comment down below. Now, as I mentioned in the intro, in this video, we're going to be talking about some very important news coming out of the DOJ in relation to the ATF's rule on 80%ers, their unfinished frames and receivers rule that was put in place by the Biden administration. This rule was recently upheld by the Supreme Court in a 7-2 decision. That decision came in a case called Vanderstock versus Garland or Vanderstock versus Bondi, and it's a case we've tracked and followed for a long time. After that decision by the Supreme Court, we saw some other similar cases trying to use the Vanderstock ruling as a basis for why courts should rule in a similar way. One of those similar lawsuits is the State of New York versus Arm or Ally, and in that case, the State of New York was going after various firearms manufacturers like 80% Arms, Brownells, Glock, Primary Arms, and others for selling 80%ers in kits. Now, in this case, New York sued around 10 manufacturers for selling or manufacturing 80%ers. Originally, the manufacturers asked the federal district court in that case to dismiss the lawsuit based on a variety of claims, including the PLCAA. Now, the PLCAA is the Protection of Lawful Commerce in Arms Act, and it should have protected these manufacturers from this type of lawsuit. And really, that law is put in place at a federal level to essentially protect these manufacturers and these companies from being held liable for third-party criminal misconduct. However, the district court denied that request to dismiss the lawsuit. Then at that time, that led these companies here to seek an appeal to the Second Circuit Court of Appeals. Currently, that's where this challenge sits. However, now one of the issues is that the prior AG's office and the DOJ got involved and supported the state of New York in this lawsuit against the companies. In fact, the prior administration asked to intervene in the case as a named plaintiff, and they were allowed in to become a plaintiff to sue these gun manufacturers. Now, that was expected out of the Biden administration, but even after the administration changed and after Trump became president, you still had some of the DOJ holdovers and attorneys who were still pushing this lawsuit against the gun manufacturers, and they were still supporting the New York lawsuit. This issue became even worse and was compounded after the Supreme Court's ruling in the Vanderstock case. In that decision, the Supreme Court found that the ATF's rule is not facially inconsistent with the GCA. Justice Gorsuch, writing for the majority, was then joined by Barrett, Roberts, Kavanaugh, Jackson, Kagan, and Sotomayor. Only Alito and Thomas dissented in that opinion. Now, after that decision, the state of New York submitted the Vanderstock decision as support for why their lawsuit should not be dismissed by the Second Circuit and why the lower court got this right. But then you also had the AG's office, who was required by the Second Circuit there to submit some additional briefs on maybe how the Vanderstock case impacts this lawsuit in New York. On April 9th, the AG's office, who was also an intervener plaintiff, also argued that the Vanderstock case supported New York's lawsuit. Now keep in mind, this was on April 9th, so just this month, which means Bondi's office, or at least some of the holdovers from the Biden administration, were still making anti-gun arguments and helping the state of New York to sue these companies. This, of course, drew a lot of concerns and a lot of negative attention to the AG's office. Keep in mind, the AG's office was directed by Trump through his executive order to protect the Second Amendment and clean up a lot of these anti-gun lawsuits. However, recently we saw that the AG's office created the Second Amendment Task Force, so that happened also this month. And the claimed goal of that task force was to implement the executive order and to kind of come up with this think tank that would target various lawsuits and correct the kind of two-way record and move away from these anti-gun arguments and instead pull their support. And their whole goal is to support the Second Amendment and come into compliance with that executive order. Well, now we just got a notice in this case that the DOJ and the federal government is going to remove their support for the state of New York, and they're no longer going to support the use of the 80% rule against these companies in this lawsuit. The notice of the AG's office to the Second Circuit states that the government respectfully submits this supplemental letter brief in response to the court's October 3rd, 2024 order, and following the government's initial submission dated April 9th, 2025, addressing the effect of the United States Supreme Court's decision in Bondi versus Vanderstock. The government's April 9th letter stated that the Vanderstock decision confirms that the district court in this case was correct in holding that the defendant's products are firearms under the GCA, and its denial of defendant's motion to dismiss should be affirmed. On February 7th, President Trump issued an executive order titled Protecting Second Amendment Rights. Among other things, this order directed the Attorney General to review all actions of executive departments and agencies to assess their impact on the right to keep and bear arms. As part of implementing the President's executive order, the Attorney General on April 8th created the Second Amendment Enforcement Task Force, which is devoted to protecting the Second Amendment rights of all Americans. Upon review of this case by the task force, the government has reconsidered its position in this case. The government's view is that the Supreme Court's decision in Vanderstock provided some clarity on the regulatory question of how best to apply the GCA to unfinished frames and receivers. But this interpretation should not serve as a basis for punishing gun manufacturers for conduct that the ATF considered lawful at the time of those sales. The government further no longer wishes to be party to this litigation. If and when this court should remand this case to the district court, the federal government would move to withdraw as a party to this case. This notice to the Second Circuit is a huge notice, and it's a great sign coming out of the Second Amendment Task Force. Not only is the federal government reversing its position on supporting the 80% rule and using it against these companies here and using it in this lawsuit, which is attacking the companies, but also they're saying that they're going to pull their support of New York. And once this makes its way back down to the lower court, they're going to try to remove themselves as plaintiffs in this case. So this is a great sign coming out of the AG's office and also this administration. It appears that the task force is taking these issues seriously, and they're listening to the concerns that we here in the community are bringing up, and they're trying to correct these issues. It'll now be interesting to see how they will respond in this lawsuit and also other lawsuits going forward. Is the office going to pull their support in a lot of these other challenges, like those against suppressors, pistol braces, FRTs, all these other lawsuits that are moving forward that were started by the Biden administration? Some of these were put on hold, but now it seems like the AG's office and the task force are reviewing these and they're pulling their support. We've seen a lot of these ATF-related cases be put on hold so that the administration can decide what they want to do, but now this is potentially a clear sign that they will be dropping support of a lot of these cases. Again, great news, and I'm happy to see that the task force is actually taking action. This seems to be one of the first things that they've reviewed, and they're going to pull their support. They've signaled they're pulling their support, and once this gets to the lower court, they're going to remove themselves as an intervener plaintiff. So now we're going to see how New York and the Second Circuit responds to this government notice. Also, we'll likely be keeping our eyes on a lot of these other lawsuits which were moved forward by the Biden administration that we did have some DOJ holdovers still making anti-gun arguments in. I would suspect that a lot of those are going to be rescinded, removed. We're going to see notices similar to this one saying that the AG's office and the task force have reviewed it and they no longer are supporting these actions. So again, great news for this case. Of course, the state of New York is still probably going to proceed forward in this lawsuit, but they'll have to do it on their own and they'll no longer have this federal support. And then also with all these other lawsuits that are out there and looming, it's going to be interesting to see which ones the administration decides to pull their support from as well. Hopefully all of them. So as we get more information, as things develop, I'll let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.